I have Jennifer with us today. She's an estate planner, and we're going to talk about what happens if your beneficiaries predecease you. And I think there's three main areas in which this can happen. So one could be you're alive, and a beneficiary could predecease you. If you're older and you need help, and you're depending upon a child to be helping you, and that child's your beneficiary, and they predecease you. And then also, once you've passed and your estate is being settled, what happens at that point? So, Jennifer, let's start talking about the first one. Like, what do you do if you're? Let's just for a conversation's sake, say like your child were to predecease you. What do you do?
So that's a great question. And we always tell clients you need to always review your documents at certain points in time. One is just a period of time. We typically recommend 2 to 5 years. The other is if something happens to one or more of the people who you've listed in your documents as either a trustee, an executor, or a beneficiary. And so if a beneficiary predeceases you, that is the perfect time for the client to dust off those estate planning documents that they did however many years ago and take a look and see what the provisions say. It's always better practice to go ahead and update the documents at that point in time so that you can proactively reference the fact that a beneficiary is no longer living. Sometimes, though, clients will look and the documents already provide a scenario in the event the beneficiary predeceases. It's still a good idea to take a look at those provisions and make sure that it still meets with the client's wishes. A great example would be you have 3 children, one of them predeceases you. Under the documents, the document may say, if a child of mine predeceases me, it goes to their children. Or if a child of mine predeceases me, it goes to my other children. So sometimes there's already built-in provisions. But again, it's better practice to go ahead and update those documents right when a beneficiary has passed away so that you can clean up the documents and not have that beneficiary listed any longer.
Yeah, and especially for people doing their estate plan the first time around, they probably don't have grandchildren, right?
Yep.
And they probably don't have that second layer of family dynamics. And so this is when like updating those documents are very important. What
Yeah.
about like, let's say towards the end of life, you lived a long life and now you're needing help from your children or some caregiver or something, and one of your beneficiaries passed away at that point. um, I guess what would you do differently then besides just updating the document? Is there anything?
Yes. So it would be updating the beneficiary designation, but also looking to see where else that potential child is listed in your estate plan. Are they the ones you've listed as your agent for healthcare decisions? Then that will be a very important document to update, even though, it's not a dispositive provision or document. It's not a document where you're giving away assets, but it's even more critical because you're older, and who's going to be making medical decisions for you is incredibly important.
Yeah, that's
Also,
huge.
yeah, exactly. And then also
Yeah.
your financial power of attorney, because you're alive, but the person you've listed to act on your behalf, if you become incapacitated, is no longer living. So that's another important document that you want to look at, particularly at that stage in life, to make sure, do you have a successor person listed? Maybe you do. I mean, again, it's better practice just to update the document so that you no longer have a deceased person listed. If you have a deceased person and the next person in line is trying to act or take authority, they're going to have to prove that that first person is deceased, and that's typically through a death certificate. So it's much easier to not even have to deal with that whole situation and just update the documents so that you have living people in place to make your decisions for you in the event you become incapacitated.
Yeah, definitely. Having clean documents could
Mm-hmm.
save a lot of headaches in a very stressful period of time.
Correct.
And so that's good. And then obviously we're going to the third scenario. Mom and dad have passed away. Their estate is starting to be settled, and then all of a sudden a beneficiary passes away?
Okay. So it'll depend on where you're at in that estate administration. So if parent has already passed away and the administration process has already started, we look to the document as far as what it provides. Does the document provide a survivorship provision? In other words, does the beneficiary have to survive the decedent for a certain period of time? If it doesn't, then even though the beneficiary has passed away, those assets will still go to that beneficiary. It's just going to be a part of that beneficiary's estate. And in that scenario, may trigger a probate administration, depending on what the beneficiary had in place as far as their personal estate planning documents. The other scenario is there was a survivorship provision in the document. Beneficiary did not survive that period of time, then again, you would look to the document to see who would then be next in line to receive the beneficiary's assets. So in all of these scenarios, we always look to the actual documents first to figure out, who's going to be receiving the assets. If again, same as what we talked about, where you have an existing estate plan, we will always talk to clients no matter what level of descendants they have in place. I will always walk through, even with the 40-year-olds who have kids who are in, very young ages. I talk to them about, we should build in provisions that deal with the next generation. And it's hard for clients to conceptualize that because it's way far down the road.
So far down.
So oftentimes we'll build in multiple generations into our documents in any event. But yeah, if a beneficiary dies during the administration, it'll typically flow to just their personal estate at that point in time because they became the vested beneficiary as of the date of death, unless there's a survivorship provision in place.
Yeah, no, that's huge to have, kind of the multi-generational viewpoint when you're looking at estate planning. And I guess, as we're talking about this, I'm realizing that some banks, some financial institutions don't even have like a per stirpe designation or anything on those TOD or POD forms, right?
Correct. So you will not necessarily find them on pay on death or transfer on death account contracts. Also retirement benefits. That's another place where we look at the contingent beneficiaries. And some financial institutions on their retirement beneficiary form also do not allow you to check the box saying per stirpes or principle of representation, whatever it may be. So, not only updating your estate planning documents, but also looking to your various beneficiary designations. Life insurance is another good example. It just depends on how involved the beneficiary designation or the financial contract is to allow different scenarios. And oftentimes they're not because they don't want to have to deal with that. So
yeah, no, that's good to bring up. So thank you for having this conversation. If you have any questions, comments, or suggestions, please leave them below. And we'll talk to you next time. Thank you.
Thanks.